Good afternoon, everyone. I'm Namita Vahi. I'm a senior fellow here at the Center for Policy Research and director of the Land Rights Initiative. And on behalf of the Land Rights Initiative and the Center, I'm very pleased to welcome all of you to the 10th talk in the Land Rights Initiative Legal History Speaker Series. So the Legal History Speaker Series, for those of you who've been with us from the beginning, is a monthly series of talks that we have been organizing in order to celebrate the 10-year anniversary of the Land Rights Initiative. The Land Rights Initiative turned 10 on November 11 last year. And, as part of the anniversary celebrations, the reason why we decided to do a series of talks on legal history was because all of our work at the Land Rights Initiative, whether it is on land acquisition, land rights of scheduled tribes in the scheduled areas of India, property rights, health rights, water rights, all of this work has used a legal historical lens in order to look at and understand policy questions in the present. And one of the reasons why we have decided to build a large body of work on the area of land and property rights is because the very concept of property is central to the imagination of our society, our polity, and our economy. And in this context, because there is very little work that has been done in the area to, because we have done extensive work in the area of property rights, the reason behind that is that the concept of property is central to the polity, economy, and society within which we live. And it is in that context that it gives me great pleasure. And it's a huge privilege, actually, Lawrence, to welcome Professor Lawrence Liang, who is Professor of Law and the founding Dean of the School of Social Legal Studies and Social Legal and Political Studies at Dr. B.R. Ambedkar University, Delhi, to give us this talk on artificial intelligence, technology, and authorship, a perspective from copyright jurisprudence in India. I've been, so just to tell you a little bit about Professor Lawrence Liang, prior to his role as Professor of Law at Ambedkar University, he was one of the founders of the Alternative Law Forum, Bangalore, where he worked for 15 years. His work lies at the intersection of law, culture, and technology. And through his academic, policy, advisory, and advocacy work, he has profoundly shaped the field of copyright law in India. But not just that, he has also been, through his academic work, he has been, teaching at, apart from Ambedkar University, various universities, including Columbia University, Michigan University, and the National Law School of India University, Bengaluru, of which we are both alumni as well. He has written extensively in the areas of intellectual property, media laws, and is also served as a board member of the International Creative Commons. He's a co-founder of two prominent digital archives, pad.ma and Indian Cinema, indiancine.ma, Indian Cinema. In 2017, for his extraordinary achievements in the areas of in his academic policy advisory work, he was awarded the Infosys Prize for Social Sciences in recognition of his creative scholarship and law in society. He's also been a recipient of the New India Foundation Fellowship. Another thing we have in common, he has co-authored Sex Laws and Videotape the Public is Watching, and has authored Guide to Open Content Licenses, published by the Pete Swart Institute in 2004. He holds his law degrees from National Law School, Bangalore, an LL.M degree from the University of Warwick, where he was a Chevening scholar and the best outgoing student, and his doctorate in cinema studies from the School of Arts and Aesthetics at JNU. So it's a very warm welcome to you, Lawrence, to CPR. And I first met Lawrence as a law student at NLS Bangalore when he came in to give 2 lectures as part of a course on legal dimensions of globalization. And I can, vouch for the fact that those 2 lectures were the most engaging and most intellectually, not only the most intellectually exciting, but also the most fun lectures I attended in over 60 courses over 5 years of law school. So, I mean, we are really anticipating a treat here. But also the fact that, over the last 20 years, and I think this is a very important moment in which we find ourselves, because you talked to us about legal dimensions of globalization 20 years ago. Right now, we are in a space where we are talking about the legal dimensions of technologization of our world. And it is in that context, even though our work has been in, different areas over the last 20 years, the common thing, as you work in intellectual property and I work in real property, land, what they used to call real property, land and property rights. And, the common thing, of course, is the sort of understanding of the conception of property as we apply to this new world that we find ourselves in. And in that context, the way we have approached the understanding of property, as we know, there are two sort of broad traditions within property theory that have, within liberal political theory, that have influenced property theory and property law. So we have the liberal political theory tradition of Hobbes and Locke, and as part of this series, the fifth talk in the series, actually, I gave that talk in the series on the history of property rights in India, and it was the history of the constitutional right to property. And in that context, I had referenced the idea of property in liberal tradition, liberal theory, in liberal political theory, where property and ownership is constitutive of individuality, freedom, and equality. To be an individual, to be an owner, means to be an owner of one's own person and capacities. And I talked about how that strand of thought really influenced the constitutional, Bill of Rights that we enshrine in Part 3, because many people, women, Dalits, scheduled tribes, they were people who did not necessarily have the capacity to exercise many rights, including the right to hold property. So for the first time, they got these rights in a very comprehensive fashion, became equal citizens with everyone else when the Constitution was adopted. And that's why, the Constitution is regarded as this transformative moment. But again, as our work has brought out with the Land Laws of India.org archive of laws that we have put together, which is an interactive exploratory archive of all land laws in India, we found, and this is the first attempt to put together central land laws as well as laws of 8 states that we've done so far. We found that there are 150 colonial laws and 350 post-colonial laws that we have put on that website. So that just shows the extent of the colonial overhang on our work in property, but also the fact that the Constitution was the transformative moment. And because, the whole purpose of creating this archive, you have created archives, is to enable other researchers to actually, analyze and identify trends within the work. And the purpose of creating the archive was to show what were the kinds of laws that are being enacted earlier, like lots of material for people to analyze what are the trends. For example, we see many laws in the post-50s, 60s, and 70s, a lot of land laws being enacted with a certain direction of thought, and then that changes significantly. The number of laws drops, but also the nature of laws that are being put into place. And that, again, then brings me to the work that's been happening recently in property rights, which again intersects with the digital work that is happening, because most of the initiatives that we are seeing, we put out a policy brief in 2022 about the policy reforms that are being undertaken in real property right now. These include the digitization of land records modernization program. It also includes the Odisha Land Rights to Some Dwellers Act. It includes the Swamitwa scheme. It includes all these schemes involve some kind of digitization of property records, drone mapping of land parcels, and in a way creating land markets in areas where there weren't land markets before. And the ostensible reason, of course, comes from this understanding of property, wherein property is a bundle of rights. And if the bundle includes rights to use, title, possession, mortgage, and so on, and the idea is that people can unlock the value of their assets in a sort of Hernando de Soto way of proceeding. So we suddenly see a lot of digitization reforms in land. So there again, there is this intersection with technology and with the way we understand and conceptualize how technology is shaping our world. But again, in the property law talk that I had given, I had referenced the critical tradition, wherein property is a relational thing. This critical tradition we attribute to starting from Hegel, Rousseau, and Marx, and to Marx. And there the idea very much is, according to Rousseau, property is a relational thing created through an illegitimate social contract that preserved inequalities as opposed to being derived from the state of nature as the liberal theorists talk about. And Marx critiqued property and liberal rights as, again, not emanating from a state of nature, but as a result of historical struggle against privileges bequeathed from one generation to another. And that critique applies as much to intellectual property as it does to real property. So, with that sort of common convergence in property and the fact, the legal dimensions of technologization, as I would call it, I just want to say one more thing, which is this idea of techno-feudalism, which is really, really something that many scholars have put out, including Yanis Varoufakis, who was the former Greek finance minister. He was an economist who became the finance minister of Greece during the Greece bailout crisis. And he has this work saying that capitalism is dead. We are now in this era of techno-feudalism. And the best example of this idea, because capitalism involves investment of capital from which profits are derived and workers are paid wages, and that's how it works. But within feudalism, there is basically rents. There's the feudal lord, and everyone pays a rent to the feudal lord for actually doing the work that they are doing. And the best example he gives is of Amazon and Facebook and all these big technological companies and their platforms, because you are actually so Amazon creates this online marketplace, and Jeff Bezos makes money not because he's selling something, a good or a service, which is what capitalism was about. You innovate, you create, you sell, but rather creating that space where all of us have to pay rent to Amazon to put our goods there and to buy and sell there. So that is the era of techno-feudalism that we are in. Same for Facebook, and the use of the algorithm. Like, they control actually what we see when we go up to look for things there. So the kind of control, which is the kind of control a feudal landlord would have as opposed to capitalism. So this idea of techno-feudalism is something that a lot of people are talking about, including some of the scholars that you were mentioning. So against this backdrop, really welcome your talk on artificial intelligence and the concept of property, sort of our existing concept of property informing these new developments that are radically reshaping our world, and how do you see how we should take things forward, both in terms of the global phenomenon, but more specifically with the evolution of copyright law in India, and with the latest developments in the OpenAI case, the various cases that are going on. So without further ado, over to you. Thank you, Lawrence.
Thanks so much, Namita, for inviting me to CPR and for this discussion. CPR, to my mind, still remains one of the most important kind of public institutions in the country. And it's extremely admirable that despite the besieged kind of state that it's been in for the past few years, initiatives like the Land Rights Initiative has actually, stayed firm in its work and also really kind of, flourished. And I really am glad for LRI completing 10 years. Congratulations on that. And as Namita said, the overlap between the concerns of an initiative like LRI, grounded in many ways in kind of investigations as well as interrogations of concepts of property, have a very strong link to, of course, questions of intangible property or intellectual property. And in today's talk, I'm going to be basically looking at some of the philosophical dimensions of AI and transformations and ideas of authorship. Now, if there is one word that should be a good candidate for the word of the year last year, it should be ChatGPT. It's really kind of transformed anything that we know about everything. But of the various stories that we all individually have about ChatGPT, my favorite one, though, is this assignment by a 7th standard or a 7th grade student, which is a handwritten assignment. But if you look at the highlighted portion, it says as a large language model. I'm sorry, I don't have an opinion on this matter, etc. It's increasingly the case that in my own experience as a teacher, I find very often an inability to distinguish between the voice of my student and the voice of ChatGPT. So recently, when I received an apology letter from a student, I wrote back saying that ChatGPT hasn't done anything to me, so he has no need to apologize whatsoever. Let me begin with a couple of stories. I'm going to begin with a couple of recent cases that have vexed the art world. What you see before you is a painting called The Portrait of Edmund de Bellamy. This was a painting that was constructed by a Paris-based art collective called Obvious in 2018. And they constructed it from WikiArt's artwork database. It was printed on canvas, and the work belongs to a series of generative images called, the family of the Bellamy. This print was sold for close to $500,000. But perhaps the most interesting bit of this painting is actually the little signature that you see at the end, because this is the signature. The signature is basically a part of the loss function algorithm code that produced the painting. In March 2023, a Berlin-based artist, Boris Elgatson, was awarded the Sony World Photography Award for a black and white photograph of an older woman embracing a younger one called Pseudomencia, the Electrician. And if you look at the painting, of course, it's photograph, it's an extremely haunting image that you have that evokes, kind of a sense of a visual language from the 1940s family portrait, but with a slightly, kind of ethereal, haunting quality. When the award was announced, the Berlin-based artist Boris Elgatson turned down the award. His photograph, he said, was not a photograph at all because he had crafted it using prompts given to DALL-E 2, which is one of the most well-known AI image generators. And he said, I applied as a cheeky monkey to find out if the competition is prepared for AI images to enter. They're not. Elgatson explained on his website, all images and photography should not compete with each other in an award like this, he said. They're different entities. AI is not photography. Therefore, I will not accept the award. My third example is a digital image, which is called the Theatre d'Opera Spéciale, which basically won the 2022 Colorado Annual Fine Art Competition, becoming one of the first AI-generated images to even win a prize. And this image was created by Midjourney using a prompt given by someone called Jason Allen and upscaled using gigapixel AI top of the form. Now, this led to a huge backlash, with artists accusing Allen of having cheated. But Allen refused to apologize and said that he had not broken any rules. The judges were unaware that the artist had used AI to generate the image. But they added that even if they had known it, it would not have made a difference to them because they would have still awarded him the top prize. Subsequent to the controversy, there have been changes in the art world and in the rules that art competitions have on what can and cannot be submitted, what information has to be revealed in terms of the use of AI, etc. Let's come closer home to two cases. The first one, before I come to this, the first one involves an LL.M student at the Jindal Global University, a student called Kaustubh Shekhawat, who was suspended for having submitted an assignment which was generated using ChatGPT. He filed a petition in the Delhi High Court in which he challenged his suspension on two grounds. The first one was a technical argument that the university did not have a clear policy, which kind of prohibited the use of AI-generated works. And then he argued that even assuming it did, the author of the work still remained the student or himself, because the Indian Copyright Act grants authorship to machine-generated works and attributes it to humans. And I'll come to this in a bit, because it really raises big questions about the relationship between human prompts and the output that arises, and who owns copyright, if any at all, in the output. The matter, unfortunately, I suppose in my mind, was settled out of court. Otherwise, this would have been one of the very interesting kind of instances where the Indian courts would have had to deal with the question of what the relationship between human and machine-generated work is. My final story comes again from India. In 2020, the Indian Copyright Office rejected an application from someone for copyright to be granted to Raghav. Raghav is an acronym for Robust Artificially Intelligent Graphics and Art Visualizer. And it's named after Raghav Gupta, a machine learning engineer who developed the app in 2019, paid for by an intellectual property lawyer called Ankit. Subsequently, Ankit Sahni applied again, this time for joint authorship between Ankit Sahni and Raghav. And the Copyright Office granted their application and granted joint authorship to a human and a machine. They subsequently realized the mistake that they'd made and attempted to withdraw the grant, except that in the Copyright Act, Now, there is no provision for the copyright, board to actually withdraw authorship that's already been granted. It can only be done by a court. So we're now in a very ambivalent position as far as Indian law is concerned on whether or not there is machine authorship. Now, all of these cases converge on the question of whether artificially intelligent systems endowed with computational creativity are capable of being considered authors or joint authors for the purpose of copyright law. In the US, there's relative clarity on this, and the Copyright Office in the US has explicitly said that authorship shall only be granted to humans. So it explicitly excludes non-humans. But if you turn to Indian law, it's a little complicated. Section 16 of the Copyright Act says very clearly that copyright can only be provided in accordance with this act. So it's a statutory right. It's not either a natural or a common law right. It's a statutory right. So the question is, how does the act deal with the question of authorship? Section 2D of the Copyright Act defines authors. And typical of lawyers, it's a bit of a tautological definition. So it says author means in relation to literary or dramatic works, the author of the work. In relation to a musical work, the composer. It goes on in this vein. But section 2D6 is the one that's very interesting. It says in relation to any literary, dramatic, musical, or artistic work, which is computer generated, the person who causes the work to be created. So the definition does not preclude non-human creators, but it grants authorship of non-human creation or computer-generated creation to the person or who caused the work to be created. Now, of course, the immediate question that arises is what does the word cause mean? Now, in a literal and a narrow sense of the term, one could argue that creation is a precondition to causing the work to be created, except that for the purposes of law, the word cause has also been interpreted, especially in the context of copyright, to mean the people or the person who creates a system that causes the work to be generated. In other words, the software developers who wrote the algorithm that enabled the creation, let's say, of an image generator. Now, this is going to be an interesting debate. It's open-ended at the moment. But while seemingly new, the debate is not as new as it appears to be. And for a long time, scholars have been exploring the intersection between intellectual property and artificial intelligence, at least since the 1980s. Interestingly, if you look, for example, at this provision that defines a computer-generated work, this is not new. This was introduced into the Copyright Act in 1992. And the Joint Committee report on the Copyright Amendment Bill of that time suggested that it was introduced keeping in mind the rapid developments that were taking place in technology, including AI. So it was rather prescient. More recently, a parliamentary standing committee in 2021 has made a recommendation, which is going to be, I suppose, the eventual position that Indian law is going to take, recommending that a separate category of rights for AI and AI-related inventions be introduced in the Copyright Act, as well as potentially in the patent law in India. This has been followed up by an AI advisory group subcommittee report, which makes a similar kind of an argument, although it's a little more cautious in terms of warning us about the pitfalls that could also arise with such a move. The other provision that is interesting on the question of joint authorship is that if you look at the definition of joint authorship in the Copyright Act, it requires a couple of things. It requires intentionality that authors have, that their contributions are merged in a manner that becomes inseparable or where they are entirely interdependent. So when you look, for example, at human-machine collaboration, one of the questions, of course, that arises is how do we think about the idea of the meeting of minds, and how do we think about questions of intentionality in the idea of the human-machine relationship? Now, all of these, of course, and it should be abundantly clear by now, that the developments that we are seeing are merely the tip of the iceberg. And we're going to be witnessing numerous conflicts in the near future on the question of AI and authorship. Have we finally reached and realized the postmodern fantasy of the death of the author? Contrary to what Roland Barthes said, that with the birth of the reader arises the death of the author, it appears here that we have the death of the author potentially, not through a displacement by the reader, but by the machine. Now, the legal form that the question takes manifests itself through the question of who can be considered an author for the purpose of copyright. And there are some technical dimensions here very clearly. With the recognition of AI authorship, what will it actually entail? Is it a corresponding equivalence in the grant of rights on the same principle as you give human beings? Is the grant of authorship to AI merely a means of furthering or strengthening the corporate stranglehold on intellectual property? Or will it perpetrate, as Namita very rightly said, technological feudalism? Assuming that AI work is to be granted copyright, how would they enforce their rights? How would they negotiate transactions such as licenses and assignments? If originality is a prerequisite of copyright, how do we determine the originality of a computer-generated work? And finally, if the term of copyright is calculated from the death of the author, what would that mean for AI, since AI cannot die? Now, these are the technical questions, but underlying the technical questions are a set of anxieties with deep philosophical consequences. Determining who qualifies as an author for copyright is not just a legal concern, but one that sparks immense amount of unease and social apprehension about the line that separates humans from non-humans. One question that encapsulates the legal and philosophical dimension is whether consciousness is essential for the grant of authorship. Historically, consciousness has been viewed as one of the distinguishing features that endows humans with specific mental traits such as emotional sensitivity, cognitive comprehension, self-recognition, independence, and the capacity for future-oriented imagination. The philosopher of science, Daniel Dennett, for example, lists 6 criteria for which he says are essential for the ascription of personhood. And these include consciousness and rationality, intentional states, sentience, and communicative capacity, moral agency, finally. He argues that we are different from and better than animals because we are different and because we have, sentience and linguistic capacity. We're different from things because we are subjects. And we're different from machines because we have consciousness. Now, one of the anxieties provoked by the grant of authorship to machines is that it seems to compromise something that has been associated with what is unique or essential to being human and what distinguishes us from animals and machines. But many of these ideas of what it means to be human comes in many ways from a very classical conception of the human, which has increasingly come under attack and challenge because the traditional idea of the human seems to, in a way, emerge from a kind of privileged normative position where the human has never been an equal subject. Nobody has been able to occupy this position of the human, and the question of what it means to be human is an extremely open-ended one. Joanna Burke, in her fascinating history on the question of what it means to be human, argues that the category of the human, far from being universal, is in fact a shape-shifting entity, and different cultural as well as religious traditions have dealt with this question of the boundary between the human and the not human very differently. So even something as seemingly straightforward a statement like consciousness being a precondition to personhood, etc., proves to be a lot more complex because the characteristics of consciousness are not fulfilled by all people, those who are in a coma or a vegetative state, and yet there's no denying that they are human. At the same time, while consciousness may not be ascribed to some animals, they have not, been historically considered to be human. So how do we deal with this? Legal philosophy has a slightly different and a somewhat particular conception of personhood. The Roman scholar Gaius's classification of law into the law of persons, things, and actions is usually cited as the first reference to the person-thing distinction. It's important to note that the legal concept of the person did not necessarily refer to a human. The notion of the person or the persona stems from the word prosopon, which was a mask, literally, in Greek and Roman theater. And Roman jurists did not equate the word persona with the word homo. One man, from Roman law's perspective, could be many persons. The concept of persona seemed to determine or be based in a way on a person's legal status. So one could be one person as a Roman citizen, another as a pater familias, Yet another, if you perform certain public offices, and depending on a context, a person wore different legal masks. So legal personhood is consequently something that's very aware of its own fiction and of its own artifice. So that rather than treating it as a natural phenomena, personhood has to be understood really in a way as an artificial identity conferred by status. So for a long time, corporations had human rights before humans did. And for even a longer time than that, slaves were considered not to be persons, but to be things or to be property. So a crucial part of personhood that begins to emerge is really the question of how persons are really those capable of possessing legal rights and obligations in a way that non-persons haven't been. Roman law, which we all suffered in through law school, has been consigned for a long time to theoretical obscurity. But there's been a recent revival of interest in Roman law precisely because of the kind of boundary blurring that you see between humans, animals, and objects. Globally, animal rights activists have been demanding that animals be accorded legal personhood. Similarly, in India, we've seen that courts have granted and read into Article 21 and the right to life and liberty, the idea of personhood to animals as well as to natural entities, including rivers, etc. In some of the US states, on the regressive side, personhood has been granted in the form of fetal personhood amendments that redefines fetuses as legal persons. So in light of these developments, the question that really arises is, what is the status of autonomous artificial agents and whether they can be attributed or endowed with legal personhood? If the entanglement of the biological, the technological, and the sociological artifacts were only earlier a matter of science fiction, we're now squarely within the realm of what Donna Haraway describes as interspecies entanglements. And this calls for a very serious reconsideration of the philosophical underpinnings of the legal concepts of personhood. Implicit in this churn, we find a set of intriguing questions. What aspects of human life define any sense of personhood? Is our personhood constituted in our capacity to communicate? Is it in our idea of self-consciousness and self-awareness? Is it in our intellectual or cognitive functions? Or is it in our ability to respond to pain and to emotion? Now, having moved away in many ways from the classical conception of the human, we now really kind of challenge traditional understandings of this unified idea of the rational human subject. And a lot of scholars have moved us towards what would be described as the post-human condition, which challenges this kind of fixed notion of embodiment, selfhood, and consciousness. Catherine Hales, for example, highlights this transformation as a reconfiguring of the human away from a stable autonomous entity into a historically contingent construct that critiques kind of the foundational binaries and decenters consciousness as the defining feature of identity. This trajectory is in many ways an exciting move on how we can return to the question of authorship in copyright law. Because we can now understand that, seen in the light of the debates around ideas of consciousness and personhood, authorship in copyright seems to be a very interesting site that functions as a technology of personification. It allows the law to distinguish persons from non-persons. We can also begin to read the dilemma around anxieties about authorship as being symptomatic of a larger set of cultural anxieties about what it means to be human in the face of technological advancement that challenge the claims of consciousness and rationality that have, in a way, defined and justified the claims to the singularity of the human. And the historic relationship between copyright, technology, and authorship, in many ways, is really the fascinating story because machines have always been at the heart of copyright. Machines invented copyright law. Before the print revolution, scribes sat backs bent over, copying by hand, generally the Bible or a whole range of other texts. The print revolution suddenly democratizes knowledge and democratizes the book as an object of knowledge, but also with a crisis. Because all of a sudden you have authors or writers asking, what is it that distinguishes their work from any other commodity? So you have, for example, the birth of the Romantic movement in literature, which was articulated on the idea that it's not the book as an object, which is, of value. The book is but the container of something else. And what is that something else? That something else was articulated by the Romantics really as the soul of the author. The Romantic genius theory, Wordsworth, Shelley, etc., at a time of great industrial churn, when everything around them is kind of transforming, you have a reason why the Romantics were kind of retreating into a pastoral idyllic, in which they were articulating that the reason that you need to protect the works or the intellectual labor of a writer is because the artist owns his or her original person or spirit. And works that are created are original in that sense, in that they originate from the spirit. Now, as Namita very rightly pointed out, there are two major traditions. You have the Lockean tradition, and then you have the Hegelian Kantian tradition that divides between the Anglo-Saxon world and the continental world. And they're interestingly brought together by copyright law. In Locke, the question, of course, was of, in a way, a labor theory, right? But Locke had something interesting. The question of personal identity had troubled philosophers before Locke, but it's really with Locke's kind of, two treatises on government, an essay concerning human condition, understanding, that we have the establishment of the most coherent theory, linking theories of identity to property. So Locke says, identity of persons lie in the memory and knowledge of one's past self and actions, continued under the consciousness of being the same person, whereby every man owns himself. So Locke formulates in this passage the psychological conception of a person. And the crux of personhood is the ability to reflect and in a way rely in a way on memory for continuity. So in Locke, consciousness is the question of mental operations that appropriates the self to itself. And where to appropriate means to identify with or make a property of. And the use of the word own is very interesting because it's both an adjective, my own thought, as well as a verb, to confess, right, to own up to. And the relationship between the self and the own in Locke creates a circularity where ideas of identity and identification on the one side and appropriation on the other continuously exchange their function and become virtually equivalent. Now, one could ask whether this was really a linguistic question. So when you say self and own in English, they're very, very tied together. And Etienne Balibar has a wonderful reading of Locke in which he disentangles the two. He says, when you turn to French, it's a little more complicated. Or if you were to turn to Hindi and say, mere apne as an account of my own, what are you referring to? Are you referring to an idea of owning, a relation like your brother? Your brother is your own, but not in the sense of property. It is, mere apne in the sense of a relation proximity. So there are all kinds of philosophical kind of, questions that could arise. I won't go into it in detail, but I just wanted to establish, this one pillar. On the other side, of course, you have the personality theory, which in the continental tradition, the focus is not so much on creating an incentive theory, as much as really on the idea of the romantic spirit that underlies, in a way, the idea of the author. And the two traditions persist today. And they are brought together in many ways through copyright that tries to kind of, resolve them, but very uneasily. So in the Copyright Act in India, for example, you have economic rights, which are very, very clearly defined in Section 14, but you also have the rights to personality, the moral rights. That really comes from the European kind of tradition. And if there are any doubts about the persistence of the romantic theory of authorship, one only has to turn to a Delhi High Court judgment of 2005, where in the Amarnath Singh case, the Delhi High Court says, many of us believe in the soul. The rights of the author are the soul of his works. The author has the right to preserve, protect, and nurture his creation through his moral rights. So contemporary anxieties about AI seem new to us, but actually they can be traced all the way back to older histories and moments within the development of copyright, from print technology to photography. It's, however, true that the rise of modern computing, particularly in the field of cybernetics, this anxiety really gets intensified. So when Alan Turing developed his imitation machine, he was already tapping into an existing set of cultural anxieties that pitted the human against the machine. The rapid development of computer systems that mimic the functioning of the human brain merely in some ways extends an ongoing tension in the relationship that we have to machines and to our conceptions of ourselves. I'm going to take a slight detour before I return back to the authorship question to tell you the story of two iconic games that happened in the history of AI. In his influential book in 1972, the philosopher Herbert Dreyfus, in a book called What Computers Can't Do, basically came to the conclusion that computers were unable to even defeat the most novice of human players in the game of chess. And this was a crucial peg for Dreyfus's argument that computer intelligence is inherently limited. By the late 20th century, a distinct genre or public spectacle emerged in the form of the man-machine contest. Just as you had in ancient Rome, the man-animal contest, here was a spectator sport that involved humans being pitted against machines. So in 1996, Kasparov, widely regarded as one of the greatest chess players of all time, took on IBM's Deep Blue in a six-match tournament, which the media very dramatically reported as the match of the century, in which what was at stake was not just a matter of victory or defeat on the chessboard, rather a struggle between human intelligence and creativity and mechanical intelligence. Newsweek declared that Kasparov is fighting for all of us, that is, with spit in our mouths and DNA in our cells. Time magazine said Kasparov is playing for you, for me, for the human species. All very, very dramatic. Kasparov himself, before the match, said that he was trying to defend the dignity of humans. Now, much to the relief of human beings, Kasparov saved our honor by defeating Deep Blue. A media commentator poetically declared that the day of reckoning had been postponed, but they also added that today we can marvel at Kasparov's resilience and brilliance. He outsmarted the brute force monster, but tomorrow is another day. It didn't take long for the tomorrow to arrive. Next year, in 1997, there was a rematch between Kasparov and Deep Blue, or we should say Deeper Blue. Billed again as an epic battle between man and machine, Kasparov was hailed as a soldier in humanity's war against our own obsolescence. While Deep Blue was described as that infamous chess program that 1 year ago threw a stunning uppercut to the human self-esteem, Kasparov lost this kind of grudge tournament. Interestingly, the day after Deep Blue defeated Kasparov, which is on May 11th, 1997, on May 12th, IBM stock surged significantly. And on the trading day that followed, IBM stock price increased by $10.38 a share, a 9% jump, adding approximately $2 billion to the market value of IBM. This rise was driven by the widespread media attention that the match harnessed and the investor enthusiasm surrounding IBM's advancement in AI and computing power. This game was one of the turning points in the development of AI. And if anyone's interested, there's a wonderful documentary called Garry Kasparov versus the Machine that gives you all of the backstory behind this game. But what happened? What is it that it did? What Deep Blue had done was they brought together a couple of things. They brought together big data, the brute power of algorithms, computational power, but added one crucial thing, the ability to learn, and for the machine to learn from its past. Approximately 20 years later, history would repeat itself because everyone said that while Deep Blue could have beaten Kasparov in a game of chess, chess is an infinitely simpler game than the popular Asian game Go. Yeah. So this is Go is played on a 19 by 19 grid, so there's 361 squares and starting points. So infinitely, more complex than chess is. But AlphaGo repeated the Kasparov IBM battle, where AlphaGo basically beat arguably the world's greatest Go player, a South Korean Lee Sedol, in 2016. The team that developed AlphaGo, DeepMind, was a team that received the inaugural Marvin Minsky Award for outstanding achievements in AI. And the award was named after Marvin Minsky because he was a computer scientist who had died earlier that year. Minsky was one of the pioneering computer scientists at MIT who was responsible for developing the first neural network, which attempted to replicate a computer version of the human brain. Minsky's work was the most notably deployed in the creation of what came to be termed as convolutional neural networks, which is the ability for computer to recognize images. And this has been developed by something called AlexNet, which won a major competition where it did something very simple. It developed a program that was able to accurately recognize images. And all of you have contributed in a way to the development of this program. If you ever encountered on the internet a step that required you to prove that you're not a robot by looking at a set of images and indicating which is a bicycle, a traffic signal, a car, or a cat, you've contributed to the training of large image recognition. The images that you clicked were perhaps added to the ImageNet database. And in 2015, in what may seem now to be a relatively mild achievement, a historic milestone was achieved when a Microsoft algorithm achieved 96% accuracy at being able to identify cat images. Humans have a 95% accuracy. So we take this for granted. But this was one of the major hurdles in computational AI, because the ability for machines to recognize images accurately are now embedded in so many of the technologies that we take for granted. This technology is what allows you to unlock your phone with your face. It's what allows Amazon to recommend products to you on the basis of a photograph. But most importantly, it's what allows the driverless car to exist. Because if you didn't have the ability in a way to kind of discern this kind of distinction, fine distinction between objects, etc., you would never have that technology. So we're at a point where it's been argued that what is it that the Industrial Revolution did? There's a very interesting graph which shows human development over millions of years. And contrary to the conceit of humans and our great veneration for our own intelligence, it's a graph that moved really, really slowly. So for a very long period of time, the graph is quite horizontal and flat. And it only takes a sharp spike on the vertical grid at one moment, which is the Industrial Revolution. So what happened? The answer is very simple. The Industrial Revolution just did one thing. We transcended the limitations of human muscle. And we're now at a time where the second graph is predicted, because we're at a time where we have reached a point where computational power transcends and exceeds the human brain. There is no way today that any chess player in the world, including Magnus Carlsen, can beat a machine. So Magnus Carlsen is rated at the highest point, 2,700 or so in the ELO, but the highest rated machine is at 3,600, right? So we've reached that point where we've reached, beyond the capacity of, and we know this. We know this from our own experiences. We know this from the daily marvel that we have of how smart AI and how smart ChatGPT is. You initially begin by saying, I'm the one doing all the work, I'm the one doing the prompts, and then you later kind of begin to eat humble pie when you realize that it's giving you sentences and ideas that you actually hadn't thought about, right? So let's return now back to the authorship debate and say that in the context of this world that we've entered into, what would it mean to go to the question, the philosophical question of AI and authorship? One of the most important kind of frameworks for thinking about authorship and copyright comes to us from Jane Ginsburg, a very well-known, respected Columbia Law professor, intellectual property professor, also the daughter of the famous Ruth Ginsburg. But in an article that she'd written, which is very influential in the debate in 2019, called Machines and Authorship, Ginsburg basically says that to ask the question of whether a computer can be an author is a wrong question. The right question, she says, is how do you evaluate the authorial claims of humans involved in either preparing or using machines that create? Now, it's interesting. Why is it a wrong question? And if it's a wrong question, why is it one that copyright law has had to ask over and over again? There's a tautological assumption underlying Ginsburg's argument, which presumes, in a way, an ontological certainty that is primarily human, and that it's primarily human who can be authors. But whether this certainty is a matter of incontrovertible fact, or is it only a contingent historical fact, is debatable. What's the overview of the argument? The argument is this. Authorship relies on two pillars. On the one hand, a mental step, the conception of the work, and on the other, a physical step, the execution of the work. The conception guides the work's execution, and the process through which an author converts a plan into concrete form, that's the process of the relationship between the two, and it underlies all acts of authorship. So the idea that a machine could be an author of a work has to then rest on the assumption that a machine is capable of carrying out both the required elements of authorship, conception as well as execution. Now, while not strictly corresponding to the mind-body divide, Ginsberg's binary between conception and execution nonetheless creates a hierarchical relationship between the two, privileging the former over the latter. But many of the examples that she cites borrows from the rhetoric of the great masters in art history, where romantic genius lies in the mental labor and artistic vision of the artist. And it's the unskilled artisans who fill in the margins. So the word marginalia comes to us from that history in art, where the master would kind of do their splashes, and the marginalia would be filled by the trainee artisans. But it's also the reason why we have such an interesting social history, because the beggars, the thieves, and the prostitutes made their way in through the margins, which is why they were on the margins constantly. Ginsberg cites a copyright doctrine that borrows directly from the history of art terms, and that's amanuensis, which is the etymological root is literally a servant from the hand, a reference to a scribe who merely takes down dictation. And Ginsberg links this to distinguish between an author and a mere instrument of execution. So you can have someone who conceptualizes a work or draws the outlines of a painting, and then you have the amanuensis, the servant, who executes the same and gives the finishing touches. So for Ginsberg, the author of the work is solely the former, while the latter is reduced to a tool or an instrument. First set of binaries. The second set of binaries that Ginsberg argues is the distinction between what she describes as an upstream creator and a downstream creator. The upstream creator remains in many ways the sole author if they have control over what the downstream creator's contribution is, and if the latter is reduced to being mere or being a mere amanuensis, right? So she concedes that there may be instances where a downstream creator could very well be identified as the sole author of a work. And that is prescient of what happens, for example, with many of the experiences that we now have with AI. She gives the example, if A gives an instruction to B, draw me a sheep, in such an instance, the downstream creator would be considered the author of the work. All of us who use generative images or ChatGPT, etc., our contribution does not really go beyond, give me an image for my talk in CPR today for my PPT, right? That's the extent of my contribution. So what are the four models? The four models that emerge is the upstream creator is the sole author of the work. The downstream creator is the sole author of the work. The upstream and the downstream creators are joint authors of the work. Or neither the upstream nor the downstream creators can be considered authors of the work. Ginsberg proposes what she thinks is a better test, an effective test. What is the extent to which the upstream creators' decisions define and bind the downstream creators' roles? Now, interestingly, again, this article written in 2019 already feels a little dated. It was written at a time when AI had not yet been deployed in the widespread everyday manner that we now witness. And the rapid development of AI for text and image generation over the last 2 years, we are continuously seeing a stream of increasingly advanced technologies and tools that challenge and complicate the framework of the upstream and the downstream relationship, making the proposition seem almost a little kind of archaic already. In the model, there is a clear preference towards human creativity. And the argument is that despite whatever the outputs of machines, at the end of the day, creativity is rooted in human design and decision making. So even when machines produce surprising or unanticipated results, they do not become authors because their expressive outputs remain traceable to human intention and programming. Now, the debate that we've seen on AI and artificial intelligence seems to be underwritten by an underlying anxiety about the erosion of human exceptionalism. And the response has been a defensive one. It's been to retreat into a classical humanism, to retreat back to the romantic idea of the author as a singular creative genius. But my argument is that this perspective feels really anachronistically when viewed in the broader history of copyright law, which has continuously grappled with the impact of automation on conceptions of authorship and originality. From print to photography, as I mentioned, each technological advancement has forced legal and philosophical reconsiderations of what it means to create and who or what can be considered an author. How am I doing on time? We're out of time. Can I take what, 7 minutes or 5 minutes? As little as I can. Okay. In bullet point form, the world of authorship in copyright history is wondrous and strange. I don't have the time to get into the wonders, but just to give you a few of them very, very, very quickly. It has had to deal with questions of whether, in the context of a seance, a spirit enters another person's body and the person writes a memoir. Who's the author of the work? Thankfully, in this case, the court said that the court has no jurisdiction over the afterlife, one of the rare instances of judicial restraint. Or if you take, in the case of photography, initially photography was never granted authorship because it didn't involve human creation. It was a mechanical process. But then you have this case involving this famous picture of Oscar Wilde, which is the Barrow-Giles lithographic company versus Saroni, in which basically what the court does is the court resurrects the romantic spirit of the author and says that the spirit moves through the machine. So literally from the question of do ghosts have copyright to the question of the ghost in the machine, you move through the entire terrain. This monkey is a very famous monkey because this is a monkey called Naruto, photographed by someone called David Slater. And as monkeys would, and as humans now do, the monkey wanted a selfie. So the monkey snatched the camera from the photographer and clicked a selfie of his own. And when the photograph was published, PETA, in all its earnest, kind of earnest indignation, filed a copyright infringement suit against the photographer, claiming it had violated the copyright of Naruto. So the question, of course, was, could Naruto get authorship? And did it satisfy the conditions required for authorship? Now, this would have been a nice story to tell, but in the face of the wondrous, strange worlds of authorship claims, what we find is that courts have always had to deal with these kind of questions. And where do we turn to? Do we retreat back to a classical kind of idea of authorship and go back to it? Or do we think about the possibility of what the grant of authorship to machines might mean, not merely from the perspective of authorship, but really from the perspective of the implications? And I don't have the time, but there are different ways that one could think about the rights question or the absence of rights question. But let me conclude for the sake of this discussion with this. If we are to live in and with technology, and Bernard Stiegler, a French philosopher, says we've always been technological. We've never been human without technology. Technology has been a way of becoming human. And if we are to live in and with technology, and we are not to inhabit a world in which the Frankensteinian myth, where technology is always monstrous, is the only mode through which we can imagine our relationship to technology. And if we are to imagine a collective future in which we do not abdicate either our political agency, our moral commitments, or indeed our humanity, then between choosing a return to romantic literature as the way ahead, and hedging my bets on an unknown, possibly dangerous, but also potentially emancipatory science fiction, I'll take my risk with the latter. I'll stop with this for now. I know I ran out of time. There's a lot that we can discuss, but hopefully we can take it up in the discussion. Thank you so much.
Thank you so much, Lawrence, for this exhilarating talk. But tell us, did the monkey win or not?
Oh, the monkey lost on the consciousness question.
Ah, I see.
But as they said of Kasparov, they lost today. Tomorrow is another day.
Right.
So,
Especially now that you were talking about the rights, the personhood of rivers, of nature, like nature, bodies, forests, and so on. I mean, there's a lot of expansion that we can probably bring and especially within the climate justice framework as
Yeah.
well. So thank you so much. I think we probably have a lot of questions from people. So before I share my thoughts and questions, I'll open it up to the room. Make sure everyone gets a chance. Yes, please. Sir. The mic. And can you please introduce yourself also?
Okay, my name is Anupam Khanna. I'm visiting. From Washington, DC. But I used to come here all the time, and I've met you many times. My question is, I think it's fascinating, especially the philosophical aspects, but most of what you're talking about is applicable in a situation where you're talking about sort of what I call extreme creativity, a single author and all that. But 99%, I would say, if not more, of our lives and of all our policy questions and debates, and in fact, in terms of economic and even social implications, have to do with chains.
Mhm.
And so the policy questions come down to, I would say, it's not just the ultimate authorship, but exactly how the chain around. So it's the issue of transformation. And the other issue is context. What is fair use and what is not? Now, I'm basically, since you're a lawyer, you realize that I'm coming back, basically posing the question of the Andy Warhol,
Right.
famous one,
Sure.
which is basically a question. And I don't know if I should, maybe you should explain it, but it's a classic case where the Supreme Court of the US has actually weighed in. And it's not clear what the larger implications would be. Is it that if I take a picture of this, I publish it in a magazine, and somebody else then transforms it greatly, then people say it's changed. The other issue is, what is it used for? And those are the things which are critical in the sort of, the real life cases involving AI and copyright. So I wonder if you have some thoughts on that.
We can collect a few questions. Are there
Yeah.
any other questions from you?
Hi, I'm Radhika. My question is, in your view, is there an author of an AI generated? Are there authors of an AI generated work, and who are these authors? And two, I mean, since obviously from your talk, I understood we have to revisit copyrightability principles because they're so interesting, related to ideas of personhood, and when that is undergoing, re-interrogation. But do you think that AI generated work should be copyrightable at all, even if one were to include the machine or those authors as include them as co-authors? Do you think that they ought to be copyrightable?
Can we take one more?
Oh, absolutely.
Yeah.
I could
Last-
he was first, but okay.
So that's fine.
That's okay.
No, it's okay. You go ahead.
I'll ask, even though I've not really had time to really frame the question while I'm asking, because I don't want to lose the opportunity. Because I don't know how to approach this in terms of asking myself who, at the end of the day, copyright or any intellectual property is giving credit to the person who does the work. So do we, as humans, should we claim credit by enabling a machine to be able to reach a point where it's creating something? For example, if I make a driverless car and that car achieves the land speed record, who is the car the fastest driver, or am I? Similarly, if I put a driver in the seat, the driver becomes the fastest driver and not me.
Absolutely. Yeah.
So I think that kind of approach, even for artistic works, is something that needs to be explored. I don't think we're at a point where you can answer these questions, but certainly something that we need to explore. And I'd like if you'd have a couple of sentences to say on that.
Maybe we take this set.
I'll take
then
this
we
set and then,
another
yeah.
three.
On Anupam's question and the example of Andy Warhol. Andy Warhol is actually such a fascinating case study in the history of, authorship debates and copyright. You know what, Andy Warhol, of course, his first kind of brush with intellectual property happens when he creates the ready-made in terms of the Campbell soup, because one of the questions, of course, is whether he's in violation of Campbell's trademark. The fact that the Campbell painting actually served as free advertisement and publicity for Campbell is perhaps one of the reasons why it didn't kind of become an all-out intellectual property battle. But more interestingly, as someone who was fascinated with impersonation, one of his secretaries was someone who also looked like Andy Warhol. And Andy Warhol would very often send him to press conferences, pretending to be Andy Warhol. But as it would happen with finicky artists, they eventually fell out. And it turned out that this secretary was also now passing off his paintings as Andy Warhol's paintings. So Andy Warhol's famous flower series was being done by the secretary. Andy Warhol recalled all of the flowers done by the painting, and he signed on them, "This is not by me, Andy Warhol." So there's this paradoxical, inscription of authority, kind of artistic authority on a fake, which then becomes the question of how do you think about. You're absolutely right that my critique of the romantic idea of authorship is really from a conception that is so outdated, because incremental creativity is the history of creativity. And that's the debate that has informed in many ways, initiatives like the Creative Commons, etc., which recognizes and acknowledges that without a rich public domain, there would be no creativity that would even be possible. So there's a very nice line which Jean-Luc Godard says, where he says, "It doesn't matter where you take it from. What matters is where you take it to." And I think that ethos is there in the last 2-3 decades, been foregrounded. Because the history of creation has involved, of course, a much wider conception. So what would it then mean to think about questions of authorship in today's time? It's again, the reason why I'm very critical of a defensive humanism, which goes back into, the human being a besieged creature by the machine, etc., to actually thinking about the other kinds of possibilities. And that's really, comes to Radhika's question. Do I believe that AI should be granted authorship? Yes. But let me qualify that. When we think about what it means to grant, legal identity to any phenomena, object, person, etc., it's not merely the identity question that has to be addressed. You also have to answer what the implications are. Here, I would say that there are various ways of thinking about what one could do. One could, for example, think about an attribution-only model, which is concerned about giving attribution to AI. So, as teachers, we have to recognize, for example, with our students that they will use ChatGPT. The question is, what norms are you going to use for the recognition of AI-generated or AI-assisted, work? And that, I think, is emerging. But does it mean that you give them copyright in the way that you do humans? We already have a broken copyright system. You have a system which is basically kind of, works very well in favor of large corporations, but doesn't work so well for actual individual empirical human creators, right? So there's a division of labor in copyright law of the author and the owner. And authors are rarely the owners of copyright. So lawyers from Penguin, for example, will tell you that rights are assigned to Penguin, even though moral rights are retained by authors. They're licensed, exclusive licenses are given to Penguin. So you have a scenario where, there is a system which is already kind of damaged. If by granting authorship to AI, we merely mean granting more rights to the creators of AI programs, which is to say that OpenAI becomes, the biggest kind of owners of copyright, then it would be futile. It would be really pointless to think about it. I think that we have to think about a system where we look at the idea of, because we have two problems here. There is an entire question of ethics, which is about, questions of attribution, questions of acknowledgement, etc. And then there is the political economy question. Unfortunately, what intellectual property discourse has become is that they have become, kind of instances where the one speaks in the language of the other. So no justification of intellectual property is ever on the grounds of profit. Intellectual property is always justified on the grounds of the poor struggling artist and for the promotion of creativity and originality, incentivizing originality, right? But this kind of confusion that the political economy realities of intellectual property and the moral justifications that they speak each other's language has to be disentangled. And I think that there are ways of thinking about, for example, a sui generis model of AI protection, where a sui generis model is not confining it within copyright, but actually creating a model, and that exists. You've had sui generis models for plant varieties, you've had sui generis models for traditional cultural expressions, traditional environmental knowledge, etc. And I think we could perhaps think of it, or finally, we could think about a civic contribution model. A civic contribution model would be one which is not based on intellectual property, which is based on exclusive rights, but really on incentivizing through other mechanisms, tax breaks, public grants, rather than granting them property rights. So how do you actually create models of incentivizing AI being contributed in a way to the public good and to the public domain? These are early days of that conversation. My fear, though, is that when the debate actually arrives in the policy arena in terms of amendments to the Copyright Act, we're going to dangerously fall back onto merely recognizing AI copyright. And that would be a slightly hazardous route to go down. I clubbed them partially in the sense, yeah.
Yeah, hi, my name is Sarthak. I just towards the end. Sure. Am I audible?
Yeah.
Yeah. So towards the end, we discussed Ginsburg's sort of formulation, and my takeaway in a very rudimentary sense was that conception is authorship, so to speak. It's more primary for authorship, and execution is still something that would be akin to using a tool.
Yeah.
So whether it's artisans or AI or any other tool, it's not exactly what authorship arises out of. Now, to stress test that idea, let's say you subject it to replication ad nauseum, ad absurdum, where to Midjourney, to Meta, to DeepSeek, to ChatGPT, to all of different platforms, I run the same prompt. They come up with different results. It's highly unlikely that they'll both return the same image.
Absolutely.
In fact, the variance across these models would be as much as me putting the prompt out there and all the people in this room making their own images on that basis.
Yeah.
So in as much as there's difference in how these different AI platforms would read the same prompt, and that difference is akin to how people interpret things differently, would it be fair to then say that all of these different platforms are tools? Like, that's pretty much the core of the question. I can try to rephrase it better.
No, got it. Very.
We can collect another set.
Thank you, ma'am. Sir, I would like to raise few issues. First of all, the scientists have started expressing their doubts about the issue of AI in the service of mankind. This is already coming up all over the world. That, like the invention of the atom bomb, the atom and the molecules and all, what has come up now? So which way we are heading to? This is the first thing. They themselves, the inventors, have started expressing doubt that it might turn against the humanity. This is number one. Number two, the next is, will AI ever be able to penetrate deep into human consciousness? Because we have been raising the question of AI and human consciousness, right? I personally believe AI will never ever be able to get deep into human consciousness, because human consciousness, as per definition, is there are so many definitions. Sorry, there's so many definitions. But what I have come about is, and I have checked it with the great person of those who have been talking about them, it is about, it's a total sum of all perceptions that turns into human. And then again, known and unknown perceptions. We have got only 5, right? So we are only betting upon the 5. But there could be more, because the mysteries that man experiences is because of unknown perceptions. So where the machine comes into? Man himself doesn't know how many perceptions are there. What machine is going to do there? So I believe the machine will never ever be able to get deep into the consciousness of human beings.
Thank you.
Thank you.
Yeah, hi, I'm Angela. Slightly digressing a little bit, but how do we determine the liability of AI? I would love to know what you think about it. For example, we had the example of a self-driving car.
Yeah.
So the accident question that, and can AI, for example, be sued for defamation, sedition when there's written word? How do we look at that also when the question of authorship itself is uncertain? Thanks. Yeah.
Yeah, we're in running the danger of extending for another 3 hours. Very complicated set of questions. On your question of underlying your question is really this, the distinction that Ginsburg makes between conception and execution. You're right, is a particular theory of the idea of the tool. The tool has always been seen in a way as an instrument, which is where the word instrumentality also comes from, an instrument and therefore an instrumentality of human, kind of interests and human kind of, operations. But in philosophy, in recent times, there's something very interesting that has emerged, which is known as object-oriented philosophy, which asks, do things have agency? Moving away from the anthropocentric perspective that presumes that man is the measure of all things and that everything around us is only... We know, for example, that when we think about particulate matter, right? Inert particulate matter has immense amounts of agency in a city like Delhi. We increasingly know that all forms of natural phenomena, glaciers, mountains, etc., have enormous amounts of agency. So one of the questions that has emerged is, how do we think about tools, ordinary tools, hammers, nails, computers, etc., not in terms of the relationship between subject and object, but when you start thinking about an object-oriented ontology. And that, for me, is actually taking us into domains where we really don't repeat the classical binaries and the divides that we have. Again, early days, we haven't seen too much thinking around it. But it's also related, sir, to your question, which is, there are 2 parts. One was a question of AI governance. You're absolutely right. One of the reasons for law and policy to exist is to understand and acknowledge that all technologies have potentially adverse effects, which is why they are regulated. Nuclear technology, have we used the full extent of nuclear technology? No, we haven't, because of its destructive capacity. But when it comes to computational technology, there is a romanticism tied to its contribution to the human good that really, in a way, is blindsided. Right? It's absolutely blind to the delirious kind of effects that it can have. And one of them, of course, is employment. There is an argument that, look, it's a business as usual argument. Automation has always existed in the history of mankind. Automation always displaces jobs, but it's, you have new jobs that emerge. Where, for example, are all the secretaries? Where are the telephone, operators, et cetera, and new jobs have emerged. And there's a similar kind of a line that's made about AI to say that AI will generate new employment. I think we really need to think hard about this. There's a book by Richard Susskind, which is basically on the future of jobs. Very, very serious, look at this question, because there are 2 things here. On the one hand, for the first time in human history, it's not blue-collar jobs that are being, under threat. It's white-collar jobs. It's still going to take a lot of money to build a robot that can cut your hair. It's much easier to have a haircut with a barber or go to a salon nearby, or to have a shave. How many of us are going to trust a robot with a knife on our neck yet? It's not that it's not possible, but the amount of money that would be required to develop that technology is much higher than the amount of money required to train a machine to read 100 billion pages. That's become relatively cheap now, post DeepSeek. So the question of governance is a very crucial one. But the question of consciousness, I think that we need to find ways of thinking about the question beyond the one-upmanship question. Who is smarter, the man or the machine? It's all right for us as some kind of, comforting self-pat to say that, oh, human creativity will never, ever be, kind of replaced. You're right. When you think about, for example, Shakespeare, yeah, sure. The classical statistical problem that has always existed is 100 monkeys typing on 100 typewriters for an infinite amount of time. When will they produce Hamlet? Has been one of the statistical questions. And mathematicians have actually attempted to answer that question computationally, saying that 100 computers randomly generating sentences, will they be? I think it's a wrong question to ask whether we will be replicating Shakespeare. No human has replicated Shakespeare. But we've nonetheless extended the Shakespearean insights, whether in cinema, whether in other kind of, literary traditions, etc. So if the question is whether an accidental creation by a machine is going to be possible to generate a work with as much poignancy as, to be or not to be, on that I have absolutely no doubt. I mean, if you take, for example, the image that I began with, which is the electrician, the image is an absolutely haunting image. Does art have the capacity to affect us, even if we know or don't know that it was not created by a human, becomes the interesting question. So the affectivity of art is not dependent either on the authorial intention or the authorial consciousness that created it. That much the post-structuralists have taught us. The question of what does it mean, knowing that it is generated by a machine, will we be able to cry to songs that have been generated by machines? Will we be able to laugh at jokes generated by machines? I'm pretty sure that we will. So this question of, do androids dream of electric sheep at night, a novel by Philip K. Dick, which became the film Blade Runner, will have to be supplemented with questions like, do humans fantasize of electric, sheep at night? And I think that that's really where we're moving to. And I don't want to reduce it into a self-affirmation. Roland Barthes has a lovely essay on Einstein's brain. It's a great essay in Mythologies. He says, Einstein's brain is preserved. He says, when you look at it, it's always a little surprising because it's really the size, it's shrunk to the size of a walnut. But many people in the thousands and hundreds of thousands go every year to look at Einstein's brain. Why? Because it's an affirmation of human capacity. That this small, tiny little brain, which we also possess, is, in other words, the infinite potential of ourselves and our humans. And Roland Barthes says it performs a mythic function. The function that it does is providing us with a euphoric security of the primacy of the human. All is well, as Amir Khan would say. So, and I think that all is not well. I think we are at a stage where there is much that is going wrong. And to rely on human consciousness to save ourselves would be an error. We've done it many times before. Let's not do it again. And finally, on the question of AI liability, I think too big a topic for me to even begin, because it would be easy to give a simple answer, but it's too complicated and a thing to go into. To be continued, as they say.
Lawrence, we have nearly 100 people on Zoom who have patiently listened to this talk. And the chat on Zoom has exploded with questions. So we'll just take a few questions from our Zoom audience now. Am I audible? Yeah. Is it possible to tell the difference between works created solely by humans and works created jointly by humans and AI? Perhaps the need is to have different categories of copyright for the two types. Has that possible remedy also been considered by different thinkers on the topic?
Yeah.
That's question number one. Question number two is, copyright law is about getting benefits, be it economic or moral benefits, which is not the case with the machines, which are mere tools to assist. You can't hear me? Don't think this is working. So I'll just repeat the question. Copyright law is about getting benefits, be it economic or moral, which is not the case with the machines, which are mere tools to assist. My question is then, why are we discussing this debate of copyright between man and machine, man versus machine? The third question, can you elaborate on the cases which some authors are fighting in courts in the US, particularly claiming infringement of copyright of their works to develop their Gen AI models? So I'll let you respond to that, then take the next slide.
Let me begin with the last one. It's not just the US. The same case that has been filed in multiple jurisdictions around the world has also been filed in the Delhi High Court. This is basically ANI, which is the news kind of network, which has claimed that OpenAI has violated their copyright by having trawled and crawl through their data to create their learning models. Now, it's an open secret. We all know, well acknowledged that in many ways, pirate infrastructure has enabled AI to become as good as it is. So LibGen, I mean, a lot of these cases. So basically, you have, after the ANI suit was filed, a number of interventions have been filed as well. So you've had, for example, the authors who have joined in on the debate, the musicians have want to join in, etc. And this is a matter that's going on in the High Court at the moment. The question is around two or three things. One of them is, the argument of the petitioners is that you're a commercial entity making a lot of money and highly valued, and you've used our data to teach your model. The argument of the respondents, OpenAI, is twofold. One is to say that while we may use your data to train our models, the output is not a reproduction of your data, right? So there's no reproduction involved over here. So the question is, of course, it's not merely reproduction. The question is whether storage of the data is itself a violation of copyright, especially because there are terms and conditions that I may have in my website and the terms of usage, which explicitly prevent or prohibit you from crawling my data for commercial purposes. And then there is, of course, the third kind of question, which is the public interest question, the fair use question. The courts have framed, is the crawling of data fair use, right? So this is a very, very crucial question. There have been groups that represent neither the large tech nor the large publishers who have considered intervening in this matter on behalf of computer science students and computer science teachers, because there's a strong public interest question here, which is basically what is known as text and data mining. Text and data mining is, the heart of AI learning models. And the question is, how do you do text and data mining, particularly as computer science students, if there is either an order that says you need the permission of the rights holders, or you need to pay royalty to do it? The educational exception in India is extremely robust. We have a research exception in section 52(1)(a)(1). We have an educational exception upheld by the Delhi University photocopy case. And I think it's very, very important to actually foreground the fact that there has to be a distinction made. In the battle between big tech and big media, you cannot have a scenario in which you end up, curtailing what it means for science and for research. So that's the update on what's happening in the courts. On the question of the different categories, you're absolutely right. The problem with intellectual property in general and copyright in particular is that it's designed as a one-size-fits-all model. Copyright is a creature of a particular technology, the technology of paper. It's in the print revolution that the four foundational pillars of copyright, originality, authorship, idea expression, all of these emerged through the technology of paper. So if you look at the history of painting, if you look at the history of photography, you look at the history of other forms of expression, they don't have the same histories, but they share, because they inherit as a legacy the idea of originality, the idea of creation that it's got from literacy or from literature. So there are fundamental paradoxes. If you take music, for example, how do you distinguish between idea and expression? I mean, for those of you who don't come from law, idea and expression dichotomy is very simply this. What's an idea? Boy meets girl, they fall in love is an idea, if protected, would mean the end of Hindi cinema as we know it. Boy meets girl in a trip, on a Ural trip. Girl comes to Punjab, boy follows girl to Punjab. You have a unique expression of the idea, boy meets girl, they fall in love, called Dilwale Dulhania Le Jayenge, right? So copyright, contrary to popular opinion or popular perception, does not protect ideas. If you ask people what is copyright for, they'll say it's about incentivizing creativity and protecting ideas. No, copyright does not protect ideas because it recognizes that by protecting ideas, you foreclose the possibility of future creation. What it does protect is the unique expression of a particular idea. Now, problem, of course, is how do you draw that line in music? Would you have, for example, in the case of music, playing a note, there are only 7 notes, playing a song at a different tempo, playing the song at a different pitch? Is it idea or is it expression? It has its own logic, but it's not a logic that has been derived from its own practice, but derived from the history of literature. So one of the ways of radically rethinking intellectual property is by saying that, look, there is a need to create norms of how people share, use, etc. But those norms have to be generated from the logic of the practice, not imposed upon it. You know, the problem with intellectual property is that it grafts a set of doctrines and principles and imposes them on all practices, and we're going to be doing the same with machines, which is the one that we have to avoid.
So a related question to the question about national copyright law is, about the convergence between global and national copyright laws. Will they converge, or will they take on separately different paths, global and national copyright laws?
Global and national copyright laws already converged. They converged through the TRIPS agreement. And prior to that, international treaties on copyright, in particular, the Berne Convention, etc. The question, of course, is WIPO going to develop a treaty on AI and intellectual property that lays down a minimum standard internationally that has to be adopted by national legislations? Now, thankfully, at the international treaty level, India has been particularly good in using the very minor flexibilities that exist within the TRIPS agreement as well as the Berne Convention. So, for example, what is known as exceptions and limitations in national legislations are left to national legislations to interpret what the scope of this ought to be. And India has used that very well in designing Section 52 as one of the widest kind of exceptions. I think we'll also need to play a role. We played a very important role at one point of time, which is at a time when intellectual property was largely determined by developed nations. It's kind of popularly rumored to be said that the TRIPS agreement was drafted by 24 American lawyers representing pharmaceuticals, the entertainment industry, and and publishers, etc. That's it. We didn't have much of a say. But what we did do, though, is that we did manage to actually have a say in certain kinds of, so there's something called the Stockholm Protocol, which was basically an exception for third world publishing, for translation rights. And I think that is a terrain that, in international policy making, we need to be talking a lot more about. Unfortunately, a lot of these institutions are also institutions that retain the global north-south kind of, power dynamic. So they've been hegemonic institutions, but I think the pushback has always been there. The history of copyright debates in India are quite fascinating. So the passage of the 57 Act, if you look at the parliamentary debates, they're not just dimensional. There are people, including, for example, the well-known poet Dinker, who's making a very strong argument for the need for stronger copyright. But there's a pushback by other parliamentarians who are talking about the absence of books and access to knowledge in the Indian context. So I think that our Indian archives on intellectual property offer a very fascinating story that can serve. And India has, the due photocopy case is, to my mind, important not nationally, but globally for what it managed to push. Should we be leading the debate on AI and copyright? Of course we should be. Will we be doing it? Different question. So
Flag that, because I'm going to get back to you on that, because I have questions, but still to take questions from a very patient Zoom audience. when even after digitization, we are not able to resolve more than 65% property issues are cases, I believe they mean are pending. How will AI help or resolve things? That's question number one. Second question, while discussions on AI generated outputs have been fascinating, there is a debate around input data and copyright. How do you view fair use text and data mining exemptions and transformative outputs in this context? What legal and philosophical questions should be considered? If AI infringes on copyright, who should be held liable? The person's name is Ashif and works at Cuts International.
Yeah.
And the third question, it relates to the question that you had asked earlier, that if I use AI like ChatGPT or OpenAI and I make an option for self-driving car to stop, but it doesn't, so would the onus of the accident be on me or the creator of the AI? So I guess liability questions are also foremost in the mind. So if you want to address those three. We're out of time for the talk, but I just think that we can extend for a few more minutes because people have patiently listened and asked
No,
a lot of
absolutely.
questions.
Yeah. And I'll try to keep them very short. Approximately 50 million cases pending in the courts in India. You stop taking cases as of today, it'll take you 450 years to clear the backlog. We have a serious problem. Can AI be used for the dispensation of justice? That a large number of the cases are property matters, and a large number of the cases are absolutely kind of, routine cases that don't throw up new questions of law and primarily about questions of fact. I think that is going to be one of the big things that's going to happen. The problem, though, is that there is something fundamentally perplexing about law, which is that law is supposed to be based on the idea of the universal. So no case is unique because it should be translated into a principle that can be universally applicable to the next case. The problem is justice is absolutely singular. Every case is absolutely unique. No divorce, no property matter is the same as another. And that's the tension that exists. I am again absolutely in favor of experimenting cautiously but boldly with ways of thinking about how there can be an automation involved in the dispensation of judges. A Supreme Court judge has said, very interestingly in the context of a death penalty case, that judges should not be robotic, which means that there shouldn't be a robotic application of rules. But as a good lawyer would, I would interpret him to have not said that judges should not be robots. So perhaps they could still very well be robots who are not robotic, and that might be the interesting challenge. On the TDM exception, failed opportunity in the last amendment. In the last amendment that happened in 2012 to the Copyright Act, there was indeed a proposal for a TDM exception, but lawmakers felt it was too early, that it wouldn't be needed. So the reason why we have the the Delhi High Court case being so important right now is that in the absence of a TDM exception, you have a lot of ambiguity on what may be allowed. Now, one has to again take a slightly broader historical perspective on this. Every time a new technology emerges, it erupts and disrupts existing relations of power between creators, users, and in a way, kind of, owners. It's a given. When radio was invented, there was a huge, hue and cry. When television came into India, the film industry cried foul. When VCRs came, the film industry declared death. So there's a very interesting, issue of Screen. The first issue of Screen in 1982 said the death of the film industry. By December, they announced their rebirth and said that video opens up new vistas of economic opportunities for the film industry. So I think that, look, there will be a shakeup, and there has to be a shakeup. And if we attempt to be status quoist in terms of preserving economic interests, which primarily are corporate in nature, we are going to be, in a way, deterring the possibilities of the technology. There are questions about how open the technology is, how democratic the technology is, how participatory it is, but those are separate questions. And we can't confuse these questions. And on the liability question, there's no getting away from it, Angela. We've come back to the liability question. See, the reason why I'm hesitant to answer the liability question is I think the liability question has to be addressed contextually. It has to be addressed For example, in relation to whether it's a question of criminal liability that you're talking about, whether it's a question of civil liability that you're talking about, etc. Is it a copyright liability kind of question, or is it, a liability for defamation? All of these require very fundamental kind of rethinks on the relationship between the idea of machinic agency and machinic dependence. Right? To what extent are we talking about machinic agency? And the point of the development of different generations of AI is that you are, even from the industry, talking about a breakaway from the older traditional models, right? So the moment you start talking about self-learning and educating kind of systems, which are modeled in many ways much closer on the neuronal kind of structure of the brain, you are going to be asking yourself questions of what levels of agency do you have. So the classical model of the tool, the controller and the tool, etc., are already in some ways, we've gone beyond that. The driverless car, people presume the driverless car to be the car that does not have a driver. That's true at one level, but the driverless car has actually been around and on the roads for the longest time. Whether you talk about the glide function, the auto kind of thing, people are there. I mean, and that technology has already been there. So all kinds of interesting questions again, but I really think that it deserves a much longer kind of laying out.
So, I mean, going back to the question of rights to machines, the perspective, this is the first question. If rights are granted to machines or to non-human elements, would it infringe on the rights of humans? This is based on the condition that rights fall under the category non-excludable goods, but are also rival goods.
Mm-hmm.
There is always a question of power involved. Including a new set of beneficiaries for certain rights would reduce the privileges of those humans who already enjoy those rights. If you could share your views on this. And related to that is another question, which I'll take, which is that copyright is a means for a privileged few. But when we talk about masses, AI is a boon.
Mm-hmm.
If debating on AI versus human with respect to copyright in some way, I guess, will debating on AI versus human with respect to copyright in some way not influence the privileges masses will get by using AI?
Mm-hmm.
And the third question, actually, I'll take two more because that will conclude the Zoom questions. If AI like Pi has the potential to generate all possible texts, images, and ideas through statistics and machine language, does granting it copyright mean allowing one entity to own all future knowledge and creativity? And the last question, what is your opinion on the case against Internet Archive in relation to their CDL service, which was provided during COVID times?
Let me begin with the last one. The Internet Archive is, to my mind, one of the great treasures of the world. And what it basically did is it innovated on something called CDL, which is Controlled Digital Lending. The argument being that if I'm the owner of a physical copy of a book and I'm a library, I'm allowed to lend the book to you. Why am I allowed to do that? Because of the principle of the first sale doctrine and the doctrine of exhaustion in copyright law, which is that you have exhausted your rights with respect to the medium of the book, right? So I can burn the book, I can tear the book, I can do whatever I want to. It's not true for a song that you download, for a software that you download, where you're paying, a license fee for the use of the good, right? So what Internet Archive did was it said, if a library digitizes its book, should it not be allowed to lend the book on the same principles that apply to a physical book, which is that it's confined? So using, for example, digital rights management, I allow you to borrow the book digitally. You can read the book on your machine for a period of like 40 years. When the book is lent to you, no one else can borrow it. It lost the case. It lost the case in a case called Hatchet. But basically, why did it lose? It lost it because one of the grounds for it being able to do what it was doing was it argued that it had what is known as the own to loan ratio. I have 5 books physically, I can lend you 5 books digitally. During the pandemic, and I believe rightfully so, it suspended the own to loan ratio. As we all know, having gone through the pandemic, and if you happen to be a student at that point of time, you did not have access to libraries. You did not have access to physical institutions. So the Internet Archive suo motu declared an emergency. And it's fighting the case, and it's unfortunately losing it in the courts. But the question still remains, which is that how do we imagine the library of the future? How do we imagine where technology allows you to really democratize your conception of what a library is and can do, but copyright confines it, right? And that's the tension that was also implicit in the first two questions, which is how do we balance between technological disruptions that benefit the masses? And you're absolutely right, right? If in the ongoing Delhi High Court case, ironically, if OpenAI wins the case, in some ways, it is beneficial to the public at large because it means that AI technology can develop in a particular way. But I would be really naive to assume that OpenAI is fighting this case on behalf of public interest. So there is this question of how do we actually foreground public interest as a voice and not as either a contingent effect or as in some ways a kind of collateral damage that arises when big tech and other players battle each other. And I think that that's where civic participation in the techno-political becomes that very important. Sheila Jasanoff very famously has this idea of civic epistemologies, which is to say that how, when thinking about science and technology, do we think about the idea of civic values? In India, the constitutional values are good enough. Values of the promise of economic justice, of equality, etc., are all extremely good normative principles to hold science and technology accountable. So yeah, I mean, the question of AI governance is going to be the next big debate that we're all going to be encountering, which is, how do we really think about governance, not again in terms of, the paranoia of the technology kind of, overwhelming us and defeating humanity, while not forgetting the fact that it indeed may have the potential to do so. If we talk about the transformation of warfare through AI, we've already seen that there's a significant transformation where you will have potentially AI making decisions that could even impinge on human lives in the near future. And we really need to start asking ourselves, what is it that we want to imagine as the sphere of regulation? India, of course, we have a slight problem because we're not too good on regulation. Very, very good on laws, right? And the laws tend to be, heavily in favor of a certain kind of oppressive state function or principle. We haven't been very good on questions of regulation, but very vital right now to, not abandon the debate and be much more vigilant in many ways on the question of how we promote civic virtues and civic value in this debate. So,
Thank you, Lawrence. I have like 300 questions, but since I have the privilege of continuing to talk with you after the talk, I'm not going to ask them. I'm just going to thank you for this really, intellectually stimulating talk, and just make a few observations for us to sort of think about. So the first thing I just wanted to note was the kind of work that you're talking about in response to the question that was asked about how digitization can actually help resolve the pending backlog of cases before the judiciary. So at the Land Rights Initiative, we, apart from the Mapping Indian Land Laws project that we call MIL, that I spoke about, which is this online interactive exploratory archive of land laws, we have this other project that we call Dalton, which is about data analytics on legal text. So what we've done is we've taken all the data repositories that we've created with the land acquisition report, the land rights or scheduled tribes, and the landlawsofindia.org archive. And what we have tried to do is to see whether we can replicate the findings using algorithms.
Yeah.
And what we find is not just the fact that you talked about the universality of law and the singularity of the outcome, but the fact that, ultimately AI is to be trained on language, and we hope to present those findings in a public talk soon. But ultimately AI is trained on language, and in law there are multiple barriers. One is the barrier of the language itself, which Noam Chomsky talks about why AI cannot really take over entirely. And the second is the language of law with its very complex legal terms. And the fact that, for example, in the land acquisition cases, we find that there are even different units of measurement. Now, of course, there's been a lot of progress that has happened. As you said, last year was the year of ChatGPT. This year, maybe the year of Grok. We don't know, but like there are things it has been able to replicate, and there are things it hasn't been able to replicate. So I think that could be the way to go. The other 2 points I just want to mention are about, going back to techno-feudalism, going back to the technological disruption that is happening, going back to what you said about the government in India not being very good at regulation, but rather good at laws, but not good at regulation, and a lot of constraint in the way things can actually emerge. I'm always, and what you said earlier in your talk about not being afraid of technology as this Frankensteinian monster. So I always go back to, this movie, the series of movies on Jurassic Park, this latest movie on Jurassic World, where, at some point when this AI generated dinosaur is kind of out of control, the owner, who's played by the character actor Irfan Khan, he goes back to the Doctor Who has been making the dinosaurs from the first Jurassic Park, and he says to him, "What did you do? Why did you, what is this monster that we can't control?" And he says, "Well, that was your order. You said you wanted more wow factor, more teeth, more, give me something more ferocious." And so he says, "But I didn't ask you to create a monster." And his response, Dr. Wu's response is, "Monster is a relative term. To a cat, to a canary, a cat is a monster." And it's just that we are used to being the monster, and we are not used to dealing with something which is bigger than us. So that's the response. And that takes me back to the theme that has been underlying all of these questions, which is that we all have differential access, not just to technology, but to knowledge. So the ability of which humans are we talking? It's not just a question of humans versus machines. It's like, which humans are we talking about? And given your extensive work on law and society, which is why I've always been a big fan of all your work, when I think of my senior citizen mother, who is well educated in English, which is the, official language, she was an English teacher, struggling with filling out forms to get her army pension. I can't even begin to talk about the Adivasis with whom we have worked on for the scheduled areas work, or the people that we interact with on the ground when 60% of Indians are dependent upon land for their livelihood. Whenever I think about, I lived in the US for 10 years, when I moved back to India, I realized that, I called it like the return from capitalism to kind of feudalism in the way society is structured in terms of social relationships are organized. We have, it's not just, as Marx said, the stages of production. Within the same time frame, it's not just about time frames in terms of the disruption with the printing press and now this. Within the same time frame, we have different stages of production and stages of social life that are inbuilt in every country of the world. And the question then, therefore, is not about man or humans versus machines, but really different humans accessing different machines in different abilities to do that. So it's really about human ability along with all of these other things. And that brings me to the last point, where you said that, the political economy implications are different from the rights implications of how we sort of understand it. And, I don't think that they can be divorced really. And I think that the question that we are coming up again and again is not, there are two things we're talking about. One is the technology, and what the questions on Zoom, and maybe you were also asking, is that the technology may be good for the masses. The question is whether our legal framework, whether property rights, whether licensing, and honestly, exclusive license is actually an assignment in a way. These are just technical differences that lawyers can work with, but in actual fact, what does it mean? And who controls the power to, organize these relations? Can we think about authorship minus all of these? I don't think we can, and I don't think we should. And I think that there are two separate questions here. One is the impact of the technology, and the other is the existing legal frameworks within which you must regulate it. And maybe that, it's not just the technology that needs to be disrupted, but those existing legal frameworks. And we are seeing that in a very big way with the world of what is happening right now. Many things that we took for granted for many, many years are being disrupted. So I'll just leave that. If you want to respond to that, great.
Maybe just one thing that I would say, which is, and this is, tribute to humans. We've kind of praised machines right through. one of the reasons why the adoption of AI in legal mechanisms in India is going to be particularly difficult is not merely the language problem in terms of the technicality of legal language. It's also the peculiarly bad language that Indian judgments are written in. And I think that, the corpus of data that we have, which is basically kind of, almost bad data, where you're not able to distinguish between in a judgment, the opinion of a judge versus what they're citing, between the operative parts of a judgment and passing observations, etc., creates a particularly unique kind of problem. And in that sense, I mean, if it's an unproductive problem, but a productive way of thinking about might be that if the surpassing of human capacity by the machine is going to be premised on its infallibility, then perhaps in the future, the greatest hope that we have of humanity might lie in the unique human capacity for error and for glitches. And it might be productive to think about how glitches become a way of thinking about the way ahead and not merely perfection.
Thank you. Please join me in thanking Lawrence for this absolutely fantastic talk.
Thank you.
And thank you all for being such a patient and engaged audience. We really appreciate your attendance at this talk and the series. And we'll be back next month with the next talk. Thank you.